Hello there, my name is Stephanie Rojo, and I'm an associate attorney at Stone Law Offices in Las Vegas, Nevada. I focus on estate planning and estate administration matters. I want to take just a couple of quick minutes to bring your attention a trend that I have been seeing in a number of my recent initial consultations for probate. The situation deals with the blended family. So we have one parent who had one or multiple children that are their biological children from a previous relationship, and they have left that relationship and they're entering into a new long-term committed relationship with another individual who I'll call the step parent. And that step parent, for all intents and purposes, has taken on the role to raise these child, even though they're not their own biological children. They are stepping in that parental figure, and they are there for years and years helping to raise this child. There's a strong relationship. Fast forward a number of years, and the biological parent has passed away, and that step parent has also passed away. Now, we come to find out that there is no estate planning in place. There's no will, there's no trust, and that step parent never had biological children of their own. They never got remarried. And I'm sitting across the table from the stepchild who's trying to address their step parent's estate in a probate matter. And they're looking to me for guidance and guidelines. And I have to share with them that the Nevada law, the Nevada statutes, have written a will for that deceased step parent because they didn't produce one themselves. And that will is essentially guidelines that are in the statute that says where the estate is going to go. So we have to go through and look at, okay, well, what family members are there for the deceased individual? Because even though that stepchild was raised by the step parent, they're not legally considered a child of the decedent. So we have to look to identify, was there a spouse? Was there any other children? Are there any parents of that deceased stepchild that are still alive? Are there any siblings? We have to look out and branch outwards into the family to see who is the closest living relative, essentially, to be able to inherit the estate. And this can be a really unfortunate situation, especially if that step parent really truly did deem that stepchild to be their own child. So the best way to avoid this situation and avoid that scenario of uncertainty and essentially excluding that child from your estate plan is to sit down with an attorney, have a conversation about the blended family, have a conversation about who you consider or who you would like to have be a beneficiary of your estate, and that estate planning attorney can create documents like a will, or better yet, a revocable living trust, which would identify who the beneficiaries of your estate are, so that when you pass away, we don't have to default to what the Nevada laws or the Nevada statutes say in terms of where your assets need to go. You get to say where your assets go and to whom and how much goes to each person. And also, on top of that, put a backup plan in case one of those beneficiaries is unable to receive the inheritance, they've already passed away, or they have other issues going on in their life, which would be further complicated if they had an inheritance. So if you are part of a blended family, if you have stepchildren that you want to make sure that this doesn't happen to, if you want to make sure that you are including that stepchild in your estate plan, I really encourage you to pick up the phone and call me so we can have an initial conversation about what your family looks like and what you want to do with your estate when you pass away. My name is Stephanie Rojo. I look forward to hearing from you. You can reach me at 702-998-0444. Thanks.